But sir and madam, let me ask you one simple question. What really happened on 14th or 15th August 1947? That particular day, a new act made by the British Parliament called Indian Independence Act 1947 came into operation in this country. What did it say? That on that particular day, the territory of India shall be divided into two dominions, two independent dominions. One, India, another, Pakistan. Now that India was not an independent country. That act did not make any independent country. That act made only an independent dominion called India. And that act also provided that there shall be a constituent assembly which are already set up by the British government itself to frame a constitution for that dominion, not for that country, dominion. And till the new constitution is adopted, the law of this land to be continued as Government of India Act 1935. And the person who is responsible to look after everything was Governor General, who was appointed by the British King. So till 26 January 1950, when the Constitution was adopted, India was 100% a British dominion. Therefore, if we say that 15th August 1947 is the Independence Day of our country, I think we are making mistakes. Now the question is, if India was totally ruled by the British law till 1950, 26 January, then up to that time, that point of time, the people living in this country were all British subjects, and the Constituent Assembly, the honorable members of the Constituent Assembly, they were also British subjects. The act which they made, which we call Constitution of India, was definitely a British act. Citizens of India,
sir,
that is the reason why, if we say that Government of India Act 1935 was continuing, then Constitution of India was a British act. If it was a British act, then it was made by the British subjects. But we the Indian citizens, why should we accept, or why we were imposed upon an act which was made by British? Now that constitution was specially devised by them in such a manner that the judiciary, legislature and the executives, they function in harmony to continue their own interest. Maybe this is the reason why we are still suffering, because we as Indian citizens, we have no power to make our own constitution by virtue of the fact that Indian constitution cannot be amended to the extent that it takes away or it interferes with the fundamental or the basic features of this constitution. Now if that be the case, then in our country, we the citizens of India will never be able to make our own laws. Thank you very much.
Vigyan, we should begin to discuss judicially.
About the fact.
Kindly address your motion to somebody.
Yes, I am addressing to those who have taken the name of Allahabad High Court, which has been said as a rotten High Court. I want to place only 3 facts. The single judge Allahabad High Court has been. Will you please hear? Allahabad High Court has a distinction of unseating Prime Minister. It has the distinction of unseating its own Chief Justice by judicial verdict. And then in this very case, single judge had passed some order, interim order, which was set aside by the latter's patent appeal, and 1 lakh rupee fine was imposed. Now the person petitioner had come. The error was committed by single judge that was already undone by the division bench. Therefore, there was no occasion to condemn the Allahabad High Court. And in that case, neither son was appearing nor father was appearing. So it was wholly uncalled for. And this is Allahabad High Court is the large, in fact, during the days of emergency, it has given the celebrate judgment also. So I suppose I strongly express my reservation about this comment, especially here.
Okay, that's all right, but should I ask one question that why don't you comment on what is presently happening in Allahabad High Court? We belong to UP, we know what is happening.
Yes, with respect.
Yes.
We are
If you want to join debate, I can already
We must make the document.
Yes, I'll put.
Not in future committee. I request all the members and fine. Let's have some discussion on the subject. Thank you.
Yes. Actually, the questions regarding the separation of powers between the three pillars of the Constitution, that is legislative, executive and the judiciary, it is all boils out of the self-disciplining and the credibility and integrity of the individuals. If everybody restrict to their powers enshrined on the Constitution, there would have been no problems. It is only because each and every organ of the state are trying to create. So my suggestion is that what about if we can restrict ourselves after that post-retirement benefits given and the lucrative attitude of the peoples who are retiring from the post, either from the legislative or from the executive, like the bureaucracy, or from the judiciary. If that can be seized, I think this will give the best answer to everything. And this is my suggestion that we can. No, my only suggestion.
My question is that in lifeline of every country, there comes time which requires radical reforms in view of situations which are radical themselves. Don't you think this idea of separation of powers would be the biggest barricade if a situation like that comes in the future when we need radical reforms and with immediate effect?
Separation of powers, the purpose of the separation of powers in 1787, John Adams, when he was moving this resolution with the Philadelphia Convention, he made a point: separation of power is not to enrich or expand, but remove any absolute power exercising by any one of the organs of the government. The very purpose is to exclude dominance. It's not meant for pro-growth, pro-development. Over a period of time, the benefit goes to the judicial activism and judiciary and the legislature and executive. All they jointly work together to promote the humanity. Converted into welfare state, they try to work together. Marginally there is overlapping. That marginal overlapping at times, that is the tension, that is Lord Wolf in the High Court of Australia when he was making the pronouncement. The separation power is consistently creating tension among these three arms of governance. It's wantonly made this separation of power. Thank you.
Sir, but if we need radical reforms, there won't be one organization which two people could go, because, for example, if we want reforms in our constitution, the very judiciary can enact any kind of legislation by saying that it is not.
Sir, I would like to just highlight one point, as you are suggesting. In fact, this aspect has been dealt with by the Honorable Appellate Court in a number of cases. And now, except that the Indian legislature cannot alter the basic steps of the Constitution, all other Parliament or the state legislature. So, one thing I would like to say before this August House for the consideration, Indian judiciary has played a significant role in strengthening the Election Commission of India's power, where the entire world is looking towards the Indian election process more. And they are trying to follow also, and the judiciary played a significant role in strengthening the powers and functions of the Indian this election law. Because of this, what I say two things which requires your consideration. A power of the judiciary. Once the power, the independent and united, say judiciary, independent judiciary. So that is the need of the hour which we have. Our Indian judiciary, there is no match in the whole of the world. A postcard, the newspaper report is treated as is a writ petition by the Supreme Court and the High Court. this power is not available in rest of the world. So we must feel proud of our system, a democratic system, and our judicial system. Thank you.
To the momentum to the speaker. Dr. P. Ratnaswamy. Dr. M. Asad Malik. Mr. N. V. Krishna. Mr. N. V. Krishna? Yes, sir. Yes. Now I will thank.
Someone. No. You want to? Yes. Thank you.
उधर से ले
आगे सर आगे फोटो
पक्का नहीं आया उधर से वो यार आपका उधर है मेरे को बेकार है बाड़ा है क्या
ठीक है सर. Today what happens, as you told that there is today now our country faces tyranny of nature. So let the judiciary then stand up for the rights of the minority, because the majority, democracy crudely defined is the rule of the majority. That's crudely defined democracy. But
here from a small country in Micronesia called Palau. I've been there for about 2.5 years, and before that I was a federal prosecutor in Washington, D.C. So that's my background. I've been asked to talk about judicial reforms in developing countries, and I've been asked to chair this in the hopes that we do not go over our time. I think what I'm going to do is cede my time to the next speaker, and if we have time at the end, I'll give my presentation. All right? So let me first start with our first speaker. Right. So let me cede my time to our first speaker, S. Prabhakaran, the president of Tamil Nadu Advocates Association and the vice chairman of the All India Bar Association.
Our co-chair, our first speaker in the co-chair, Mr. S. Prabhakaran, President Tamil Nadu Advocates Association, Vice Chairman, All India Bar Association.
And ladies and gentlemen, all persons shall equal before law, and everyone should have access to the courts. Any person should have the opportunity to defend his rights, and everyone shall be entitled to fair and a public hearing by a competent, independent and impartial court established by law. These cardinal principles are based upon the universal principle. It draws upon the historical experience of many lands. It is impossible to ensure the rule of law upon which other human rights depend without providing the independent courts and tribunals to resolve. The alternative to the rule of law is the rule of power, which is a typical arbitrary and self-interested and subject to influence which may have nothing to do with the application of law or the factual